Good morning, everybody, and welcome back to the District of Columbia Court of Appeals. We are back here on the emergency juvenile detention matter in RE J.R.R. number 25 FS 967. Whenever you're ready, Ms. McDonald.
Morning, and may it please the court, Sarah McDonald on behalf of Appellant J.R.R. I'd like to reserve 3 minutes for rebuttal. There are two independent bases for reversal here, but I want to start with probable cause because if the court agrees with us and determines that there is no probable cause underlying J.R.R.'s detention, it would prevent everyone from coming back into court if J.R.R. is detained for new reasons on these menial charges down the line. We've given the court two ways to look at this probable cause argument that show that the petition fails to charge the offense of tampering. And in response, the government really only says, well, what about this other offense of contempt? One way the court can look at the probable cause issue is to apply all of the ordinary tools of statutory construction to the tampering statute, starting with the plain text, which leads to the result that required in 1211 means a requirement imposed by someone with authority. The other way doesn't require any interpretation of the tampering statute and just follows from this court's decision in QB. The condition was part of a conditional agreement premised on the pain of detention. And when the prospect of detention was taken off the table, there was no requirement for J.R.R.
So, counsel, you agree, right, that both constitutionally and statutorily, JR could have been subject to a GPS conditional release requirement prior to the probable cause hearing. Is that right?
I actually do think there are serious questions even at that point under Gerstein. I think the court doesn't need to address them because it is quite clear that when you're at a point where there has been an actual finding by a judge that there is no probable cause, then there are no questions whatsoever.
Well, but the question for me though is, and I'm unclear on how this works still, to my regret, but there seems to be some disagreement about whether there could be so everyone agrees that the charges are still in place, right? Despite the no probable cause finding.
Yes, and I actually think that makes sense and isn't something that's so aberrational to the juvenile context if the probable cause hearing is looked at as the analog to a Gerstein in adult court.
Okay,
And
so then the government argued in its briefing that there could be another chance at a probable cause hearing. They could have a second bite at the apple. And your briefing suggested that at least on the facts here, that wasn't really in play, that Magistrate Judge Jones kind of said, I don't want to, I hope I don't see you again, so forth. But do you agree that there could have been a second probable cause hearing in this case?
No, the government has no support for the idea that that could happen. They haven't pointed to instances of it happening. And I think that exactly as Your Honor pointed out, the statement from Judge Jones indicates he's not saying, when I see you back here in a couple weeks, if the government finds the right witness, then I'm going to detain you. He's saying, if I see you in a new case and I find probable cause in that case, then I'm going to detain you. But I think that for the question of authority, I think there is a constitutional problem either way, and Gerstein requires that before any significant restraint on liberty, there be a finding of probable cause. And the government has pointed to nothing suggesting that that is different in the juvenile context.
Well, and I don't want to monopolize this, but the issue for me is if there is a second chance at a probable cause hearing, then that period between the first no probable cause finding and any second theoretical probable cause hearing, second bite of the apple, is analogous to the prior to the first probable cause hearing period, right? Where, and I know you've sort of caveated whether you agree that release conditions could be imposed at that time, but if they can, then those two periods could be arguably equivalent. in the juvenile context such that release conditions could be imposed at that point too. Do you understand my question?
I understand the question. I think that sort of the two analytically separate ways to think about it turn on, the agreement and the absence of authority. And I do think that it's clear that after a finding of no probable cause, there just is no authority. The imposition of a significant restraint on liberty is unconstitutional at that point, whatever the constitutionality.
What case do you cite for that proposition?
Gerstein provides that.
Gerstein involves somebody being held, right?
But Gerstein says that probable cause is a prerequisite to any significant restraint on liberty. Gerstein explicitly recognizes that conditions of release can impose significant restraints on liberty. And this court has held in Davis that GPS monitoring is a condition that imposes a significant restraint on liberty. And the government doesn't challenge.
So then
any-
Gerstein would prevent, I mean, you basically alluded to this in your answer to my question a few minutes ago, but then Gerstein would preclude GPS monitoring prior to the probable cause hearing in the first place. And I don't think that's ever seriously been contended. Maybe you are contending that now for the first time, but no one has said in the juvenile context that you can't impose GPS monitoring prior to the probable cause hearing. And if Gerstein is your support for why you can't do it after then it should be it should also preclude it before the probable cause hearing.
Yeah, I do think that that's right, though I think that we're just in a world where it is all the more clear after there has been a judicial finding of no probable cause, and the probable cause hearing that happened here, right, is more robust than what happens in the adult context under Gerstein. And so once there has been a hearing subject to, the adversary process, and there's a finding of no probable cause, I think that we're in a world where there just can be no real question that it is unconstitutional to have anyone subject to the significant restraint of GPS monitoring in that world where sort of their innocence has been their presumed
So I don't want
non-involvement
to
has
take us sideways
Yeah.
then, but seems like where we are in the argument seems like a good place to ask then about forfeiture at that point, because it seems at that point, at the finding of no probable cause, should have been an argument that the GPS monitor has to come off at this point, right? And I realize that your response may be just that didn't happen, and it's unfortunate that that didn't happen, but how does that relate to the forfeiture question?
Yeah, I think that doesn't change how we interpret the tampering statute. And so the question here really is, was JR required within the meaning of 1211, the tampering statute? And I think that cannot turn on, was it challenged? That either has to turn on, was there authority, which is baked into the concept of a requirement? Was there authority to do this? And the tampering statute is concerned with interference with the government's lawful ability to monitor someone's whereabouts. And when the government when there is no authority to be monitoring someone's whereabouts, I think it's perverse under the tampering statute.
What I don't understand is this notion of there is no authority. If the judge says, I'm contemplating ordering you to wear this GPS monitor, and the defendant says, that's fine with me, Judge. I will obey that order, Judge. And the judge issues an actual order. By any normal speech, that is requiring the person to wear the GPS monitor. And it's hard to believe that anyone in the courtroom hearing that would have thought, oh, well, this allows him nonetheless to tamper with that monitor with impunity. He can't be prosecuted for doing so when he's just agreed to do so. I find that very strange. To me, this is an obvious case in which, under ordinary speech, he was required to wear and then maintain that GPS monitor, and he didn't do it. And the fact that he could be held in, regardless of whether the order whether the court had the authority to issue that order. The fact that if he didn't do it, that order could be backed up with a contempt finding only underscores for me that he was required within the meaning of the tampering statute to use it. How do you respond to that? I think he's forfeited. I mean, I think he's forfeited his objection by acquiescing and with counsel in the judge's order. And it was just like, any other condition of release from his perspective.
So I want to make clear that he could not, under this court's decision in QB, be held in contempt. And I think that's why the juvenile context is different. So for conditions of release in adult court, there's a statutory provision providing that someone can be held in contempt for a violation of a condition. That does not exist in juvenile court, and QB makes that absolutely clear. And I think that taking the idea—
Facts of QB are on all fours with the facts of this case?
The facts of QB, so to the point whether a juvenile can be held in contempt for violating a release condition, QB, that is the direct holding. That is squarely what QB was deciding. And QB held that because the way that release conditions operate in juvenile court, unlike in adult court, there's not a sort of a statutory provision authorizing this is a mechanism of contempt. QB says that this stems from the nature in juvenile court of these conditions as a conditional order, and that's why QB analogizes, as we have, to an agreement where the only way to enforce the conditions is on pain of detention. And so that's why it's significant here when detention was taken off the table after there was a finding that there was no probable cause.
So where that leads you is to say that the agreement was illusory. It was just a complete nullity. That's where that leads you, because you're taking the position that although the judge looked at the guy and said, "This is what I want," guy says, "Okay, I will do that." It's completely illusory and completely unenforceable. I find that a little bit of a stretch.
I think it becomes a nullity, I agree, after there's been a finding of no probable cause. And so JR, like to the extent we think about this as an agreement, right? JR agreed to the conditions on pain of detention with the prospect of detention, just like QB did, saying, I recognize that you would try to detain me.
The conditions on pain of being charged with tampering, if he tampers with I mean, he's detained here because not because he didn't comply with although it's relevant, didn't comply with the GPS monitor. He's detained because of all the evidence that he couldn't be relied upon to show up in court. And if one accepts that evidence as sufficiently probative, that's perfectly good reason to detain him.
But detaining him required probable cause. And in the UUV case, the court found no probable cause. And so
That's
everyone
true, but
agreed.
in the tampering case, they did find probable cause.
But it found the tampering statute provides that someone is required. And so the point is that
This gets back to the meaning of required.
it gets back to the meaning of required. And
Even if you are right that contempt is not an option, I still lean to the view, I think, that, well, he was still required to wear that. Nobody entrusts him with a fairly expensive GPS monitor device to wear and says, you have to wear this and maintain it without thinking that he's been required to do those things.
so I do think that sort of being required to follow court orders in a general sense is different than what it means to be required to wear a device within the meaning of the tampering statute. And that's why we've pointed to the legislative history and the legislative purpose of the tampering statute, where it's clear that what is animating that is not like in the contempt context, sort of respect for court orders, that courts only function if courts have the ability to issue orders, and whether or not they turn out to be valid, people have to follow them. What is animating the council in the tampering statute, and I think this is manifestly clear from the 2016 amendments after this court's decision in Hunt, is do the people who are imposing the monitoring requirement actually have the authority to monitor someone's whereabouts at all times? And that was raised as a concern in the amendments to the tampering statute in 2016. The idea that, no, when CSOSA imposes monitoring as a sanction, they do so without authority. And the council doesn't say, well, the tampering statute is about, following what you're supposed to do. The council says, oh, no, CSOSA absolutely does have authority, citing Griffin v. Wisconsin for the proposition that they're saying, we're seeing this as only a statute that is encompassing interference with the lawful authority to monitor someone.
So is your view then is that even putting aside QB and contempt, like let's just assume that he could be held in contempt, that still doesn't satisfy the required element of the tampering statute?
Right, because what is animating contempt is an entirely different statutory purpose created for to accomplish different ends. And so there, when we talk about, well, people are required to follow court orders, yes, in the contempt sense, contempt is grounded, as this court, as the Supreme Court has made clear, in sort of courts will only function if there is respect for court orders. And it's quite clear that that's not what is animating the tampering statute, but I would point out actually that
I
even in the
want to make
contempt-
clear that my position doesn't really turn, what I'm impressing you on, doesn't really turn on whether in fact, under our current state of the law, he could be held in contempt or not for violating that court order, which was in the form of an order. So, I don't know whether you're right about that, but I don't think, even if you are, that contempt is not an option. My view is that just in normal parlance, he was required by a court and was supposed to obey that order. Otherwise, this was a complete nullity, and that's a very odd thing to say.
I think in normal parlance, as we've cited, required means required by someone in authority. And that's why I think the government's sort of only attempts to construe required in the tampering statute as filtering through the concept of contempt just don't get us very far.
Well, the judge had
Contempt-
one could say the judge had apparent authority, and J.R.R. and his counsel forfeited any claim that he didn't.
So
Not objecting to it. We'll do it, Judge.
again, I think
And I'm sure they were happy to do it because the government could have filed a motion for a reopening of the probable cause hearing to get the right witness down.
authority in the contempt context, I think, is important, just based on the general principle that, right, courts have authority to order people to do things, and they have to be enforced whether or not valid. But when it comes to what the authority that we're looking for in the context of the tampering statute is, the council has made clear that it's about authority to monitor, not authority to tell someone what to do. It's that they have lawful authority to monitor someone. And again, I think the analogy to contempt here is in a posit because of the different purposes that drive that area of the law. But even under contempt, if an order, this court has made clear, if an order is patently unauthorized, that is not even the subject of a contempt charge, even though in the contempt context, it is about respect for the court. And so here, when what the government is saying that J.R. was required to do was wear a device around his ankle all of the time that monitored his precise whereabouts, that subjected him to additional charges after there had been a finding of a judicial finding of no probable cause, that's a manifest constitutional problem. And so to say that there
Suppose the
was,
following hypothetical. The judge is saying, look, J.R., would you be willing, I don't have the authority to order it, but would you be willing to wear this monitor? It will ensure, it will help me believe that you will show up in court on time. And J.R. says, yes, Your Honor, I will wear that. I know you don't have the authority to actually order it, but if you ask me to do it, I will do it. And I'll put that GPS on. I will take care of it because it's valuable property. I will keep it maintained. and so forth. And his attorney says, yes, that's what we're willing to do, Judge. Now, if he then doesn't do it, the judge can't take that into account and say, and he then destroys the monitor or doesn't maintain it or loses it or whatever. The judge doesn't have the authority to, under that hypothetical, well, not the judge, the government doesn't have the authority under that hypothetical to charge him with tampering.
So I guess I don't want to take the sort of agreement analogy too far, right? And I think the idea that sort of a 13-year-old child with limited capacity is sort of meaningfully making this agreement. I know there's a lawyer involved, but the agreement when it happened, right? And QB says this is like on pain of the prospect of detention, like I will follow these conditions so that you don't try to detain me. And so once we reach the point where there's a finding of no probable cause and everyone agrees that JR can't be detained, I think sort of,
But
by
he still
analogy,
agreed.
even to
But he
contract,
still agreed to wear
he did not agree after there was a finding of no probable cause. The condition was imposed beforehand. And so I think for this to be
Yeah, well,
true, there would have to be a
he did-
new agreement.
Implicitly
Sure.
agreed, I think, is the point.
And then when no probable cause was found, he acquiesced in it. He forfeited any objection to being continued to wear it. That's what it looks like.
By analogy, if this is looked at as an agreement, it's quite clear under contract law, the doctrine of frustration of purpose, that when the entire premise of an agreement falls through, and here the premise was, I could be
What's the
detained.
agreement? There is no agreement. The judge didn't ask him, well, will you agree to do X if I agree, or I'll agree to do Y if you'll agree to do X. The judge just said, I'm imposing this requirement.
And I guess the question was, well, if the court didn't have authority to do that, but instead sort of entered into a consent agreement, and I do think there are serious questions about the authority to do this as a freestanding order. And QB says the only way that conditions can be imposed in the juvenile context are pursuant to this conditional agreement on pain of detention. And so I recognize that if I don't hold up my end of the bargain, I could be detained. On August 27th, QB cannot be detained. So if we're looking at this as a
But he'd be
contract,
prosecuted for contempt.
he could not under QB be prosecuted. for contempt.
I misspoke. He can be prosecuted for tampering.
He could be prosecuted for tampering if he were required to wear a
We're
device.
going around this.
And again, my position is for one of two reasons, either because a requirement under 1211 has to be a lawful requirement, and the requirement was, such as there was one, was unconstitutional, at least as of August 27th. That's one way. The other way was, if this is sort of an agreement by basic principles of contract law, once the premise falls out, there is no remaining obligation to duty to perform for the person who sort of the basic
Suppose-
premise has fallen out.
One last question. Suppose the judge had said, well, I really am thinking that I'm going to detain you or impose other conditions. You don't want me to you don't want those other conditions. I won't impose them if you'll wear this GPS monitor. That would actually be the kind of contract or agreement you're describing. And it may be maybe that's a fair characterization of what happened here. It was 50 years ago that I last practiced in juvenile court. Consent agreements, if you have a consent agreement and you violate it, what are the consequences?
So I'm not, this is not,
You've
I
been
think
analogizing this to.
analogizes to consent agreements, right? And what QB says is the agreement that the conditional release order, the consequences for that cannot be contempt. Unlike in the adult context where there's a statutory provision providing for contempt, QB takes that off the table. And that is squarely the holding of QB. So what QB says is the only mechanism for enforcing a violation of release conditions is detention. Once a child is not detainable, there is no way to enforce it, and that is why it becomes a legal nullity. And that's not, right, so different than how this works in adult court. Under Rule 5, when we're in the context of a Gerstein, if there is a finding of no probable cause, the court must release the defendant without significant restraints on the defendant's liberty and must order the defendant to appear for the next court proceeding. And that is all that the court has the authority to do, is to make sure that the person keeps showing up for court. They don't have authority to impose significant restraints on liberty, and GPS monitoring is unequivocally a restraint on liberty. And I think here, when we're talking about JR needing to show up for court, again, the proceedings here are based on failing to charge a GPS device for someone with an IQ of 55, a GPS device that he never should have been on. And I think to the extent that Your Honor has concerns about destroying a GPS device or something like that, there are clearly charges like malicious destruction of property that could reach those sorts of things. But we're talking about an exceedingly narrow class of cases where after a judicial finding of no probable cause, someone still unlawfully remains on GPS monitoring. That is the only, when we're construing the tampering statute, this isn't sort of a broad interpretation that is going to have all sorts of these consequences. In the ordinary course, there's no question judges have a lot of authority to put people on GPS monitoring. But here, when we're talking about—
So why didn't his counsel go back to the court and say, you got to take them off the GPS because no probable cause has been found?
I don't know, Your Honor, but it
I mean, that
can't.
sounds like a forfeiture.
And I think if we were challenging now that condition, that might be different, but that's not what we're doing. We're here figuring out what tampering means, and we're here figuring out what the word require means. And in the face of it being unconstitutional for JR to be on the significantly liberty restrictive GPS monitoring after August 27th, I think that the interpretation of the word require in 1211 cannot turn on, but counsel didn't object. There's a clear constitutional problem. It was patently unauthorized and unlawful for JR to be on GPS monitoring at that point. And that's all that this interpretation of require
Constitutional claims can't be
touches.
forfeited?
Sorry?
Constitutional claims can't be forfeited?
I'm not saying that constitutional claims can't be forfeited. I'm saying that again, it all goes back to the meaning of require. And what was the counsel trying to capture in the tampering statute? And it's quite clear from the counsel's own statements in the committee reports on the 2016 amendment that we are concerned with the interference with lawful monitoring of people, because GPS monitoring, when it is used as an alternative to incarceration, has public safety benefits. And if people are able to thwart that when the government has authority to monitor them, that's a public safety problem.
I hate to take us all the way back to my very first question a half hour ago, but Judge Glickman, in one of his questions, premised it on the notion that the government could file a motion to reopen the probable cause hearing. And can you just say yes or no whether that was possible? Okay, and then I know I said just yes or no, but now can you tell me why that wasn't possible?
The government hasn't pointed to anything that makes that possible. I think the idea, like, the government has no support that this happens, that it is possible. We have a statement from a judge, I think, very clearly indicating that it's not possible. And I think it's not as if the juvenile court is so different and it's so odd that the petition remains. I think, again, we would be in the context of, like, post, there's no probable cause on the Gerstein in adult court. In the same way, the charge can remain, but what is clear there is there can be no significant impositions on liberty. And there's no sort of second bite at the apple, really. And there's even less, there's nothing that the government has pointed to there for that idea. And if Gerstein makes clear that without probable cause, you can't impose liberty restrictive conditions like GPS monitoring, I think it has to be manifestly clear that after there has been a finding of no probable cause, that's unconstitutional.
Can I ask something I'm confused about? I understand after the finding of no probable cause, the child cannot be detained. But what is happening to the case after that? I understand this oddity of or I don't know if it's an oddity, but the probable cause issue being more about a detention than about the, viability of the actual case. What is normally happening at that point?
Yeah. So in MAPV Ryan, this court rejected the idea that just simply the charge alone requires a determination of probable cause. So again, we're in the world like in adult court where we would have a Gerstein but a finding of no probable cause. In adult court, what the rules specifically provide is the defendant must be released without significant restraints on liberty and must order the defendant to appear for the next court proceeding. And so in the same way, sort of the case can proceed, but the authority of the judge of the court over the person becomes limited to having court hearings happening. And I think this goes back to sort of segue into the 2310 analysis and the reasons that JR is not detainable on those grounds. Sort of the only justifications that the government has offered for why JR is detainable is to secure his presence at the next court hearing. And while that is, if it were met, permissible basis under the statute, I think stepping back here to the context of this case, where what we have is an incompetent child for whom there cannot be a trial at any point in the foreseeable future, and that the trial would be the charges that JR is detained on are misdemeanor charges for failing to charge a GPS device that he never should have been on, for someone with an IQ of 55 who's on a first or second grade learning level. I think, that is the context of the case we're looking at here.
What would the normal practice be? I understand we're looking at statutory interpretation in a situation in the one we have here before us, but if hypothetically someone had said, oh, okay, no probable cause, please remove all these conditions, which are really conditions involving conditions of release, basically, would the government have agreed, yeah, we have to do that? Or do they, what's the practice?
I think what the Constitution makes clear, right, is that those conditions can't continue happening. And so I think if that had been challenged, I can't say for sure that the government would have agreed, but I think it's telling that the government in its briefing here really hasn't posed much challenge at all to the idea, A, that GPS monitoring is a significant restraint on liberty. This court has held that in Davis. And B, that there are constitutional problems with having significant restraints on liberty follow a no probable cause determination. And to the extent that the government has tried to say the juvenile context is different, it again cites only MAPV Ryan, which predates Gerstein and isn't answering any question at all about the constitutionality or permissibility of release conditions. It's again just answering the question, does in juvenile court there need to be probable cause to support the petition at all, as there would be in sort of the felony context in adult court. And that is the only thing the government says as a reason that it was not unconstitutional for JR to be on significant GPS monitoring after a finding of no probable cause. And that the case is really completely in a posit. And so again, at that point, the JR would still have to appear to court hearings, and there's really no indication whatsoever in the record that that would be a problem. JR has appeared for every court hearing. And I think the government tries to make this a case about, well, appearance at court hearings isn't dispositive under 2310A2. But what the council has made clear and what this court has made clear is that we have to look at the particular circumstances of the child, at the individual child, and that detention has to be considered as an absolute last resort against the harms that the council has recognized of detention for any child. And here, the harms for this child are especially acute when we have a particularly young, particularly vulnerable child who the record shows is being taken away from services that he needs when he's in detention. The council has said you have to look at that backdrop of wanting to avoid detention and say, nevertheless, detention is required to secure the child's presence at the next court hearing. And the record here simply cannot show that.
You're saying that we have to look at the particulars of the child before the court. And Juvenile Rule 106 talks about the factors that the court can consider. And you seem to be agreeing that mere prior attendance at court hearings or compliance with the requirement to appear at court hearings is not dispositive one way or the other. And so what do you say about the fact that here, we can argue, and you have argued with your colleague on the other side about the abscondances and the curfew violations, and let's take those out. But I count 5 no-shows for CSS appointments, if I'm right about that. That seems to go an awfully far way for the court to be able to say, you're not doing what you're supposed to be doing. And so I can't count on you to show up to court. And to the extent your attorneys are standing here saying they will get you to your next court hearing, they haven't gotten you to 5 appointment with CSS.
And I have 2 responses to that, both sort of factual and statutory. And so the council, when it provided these strictly limited bases for detention, said presence at the next court hearing. It did not say compliance with release conditions or sort of meetings and evaluations that could move the case forward. And it obviously knew how to do that because in adult court, non-compliance with release conditions is an independent basis for detention. And the council is saying, that's not what we're worried about. We're concerned with presence at the next court hearing. And it has said that sort of misbehavior, non-compliance, those aren't reasons for detention. And here, they're just not reasons to show that JR isn't.
Reasons for detention. I'm saying that just stick with 5 failed no-shows with probation officers are indicia of a likelihood to not appear at the next court hearing. And it seems like Juvenile Rule 106 would permit that consideration.
So even non-compliance with release conditions isn't an enumerated factor in Rule 106. And I recognize that it's not an exhaustive list. I also would point out actually that Rule 106 still reflects the pre-2016 version of 2310 before the council sort of indicated this manifest intent to limit detention even further. And so I think if anything, the Rule 106 factors have to be understood as more permissive of detention than the current version of 2310. But setting that aside, I think that's why I would point to the facts of those non-appearances here. And what the record shows about those CSS visits is that JR's mother could not take him to those visits because they happened in the evening when she was at work. The probation officer is expressing concern about his mother not being able to show him how to get there. And I think the government's suggestion that there's nothing in the record to show that JR just couldn't have gotten there on his own is really doesn't hold up when we look at the full picture of JR, who's incompetent to stand trial, who's on a 1st or 2nd grade learning level, who has an IQ of 55, who people have made clear has difficulty understanding things. I think it's totally reasonable to think that a child needs support to get places, and the record shows that his mother's schedule has conflicted with the CSS visits in a way that the record also shows hasn't been the case for court, which happens during the day, not in the evenings when his mother said she works. And again, because what the counsel is concerned with is presence at the next court hearing, I think it matters that defense counsel, the defense team is at the court hearings and can help ensure that JR gets to court.
Is
And
there any
so-
record support for that? You know, you've been saying on appeal that counsel are really diligent about getting him to where he needs to go. Now, they didn't get him to any of the CSS meetings, but is there any record support as to counsel's role and efforts in ensuring that JRR would be at court?
Where there's record support in that he has always appeared for court and that defense counsel is naturally sort of inherently always going to be in court too. And so I think the idea that defense counsel would have an obligation to take a child to CSS visits, which aren't sort of mandated as reasons to avoid detention in the same way that court hearings is, I think is asking too much. And the juvenile
I think that
state
cuts it to me.
contemplates.
You're just arguing that counsel had the opportunity, if counsel wanted to exercise it, to be available to help him, but you're not arguing that there's any record support. The counsel has actually been active in making sure that JRR was in court. I mean, I must tell you, if I were the trial judge and I saw this record of a child who misses all his CSS appointments and who absconds and is hidden out in, you know, abandoned buildings and leaves home without his parents knowing anything about it and misses school and all the rest, I would have thought this is clear and convincing evidence that something is required here to ensure that he shows up at trial. I have no confidence just because he'd been at prior court hearings that he would come to court in the future. I mean, all his other behavior suggests that he's completely unreliable. And the fact that he has mental deficits, intellectual deficits, and other problems is sad, but it doesn't, I mean, one could say, if anything, it increases the unreliability that he has. And that's sort of, you sort of hate to say that to hold it against him. But this strikes me, if I were a trial judge, as a paradigm case for someone who cannot be relied upon to do anything he's supposed to do.
I don't disagree that the record shows that JR struggles to always do what he is supposed to do when he's on his own. But the juvenile context in terms of showing up for court, which is all that 2310A2 is concerned with, contemplates that children are going to have assistance there. And so I think the assistance of defense counsel means something. And I think to the extent that we're looking for sort of affirmative record support about that, I think that flips the burden. The government has the burden to justify detention by clear and convincing evidence. And what the record shows is that whatever struggles there have been for JR to comply with other things, he always gets to court. And I think the way
With police help, evidently.
there's no record evidence that he's ever come to court only because of police help. He's showed up in court. I mean, granted, he's had additional court appearances in the time that he's been detained, but even when he was not detained, he got to court without police help. And I think that, again, 2310A2 isn't concerned with, does a child want to come to court and do it on their own? It's concerned with, do they get to court? And he does get to court. And I think in the context of sort of this sense that detention would help facilitate these other processes. And so what we have from sort of the probation officer, from the court, is not so much I'm worried about the next court hearing, it's I'm worried about moving this case forward. I'm worried about evaluations happening. I'm worried about competency restoration happening. Those aren't statutory bases for detention. And I think when we look at what JR needs, I think there's no dispute that this is a child who needs services, right? But what the record shows is that the detention is actually inhibiting JR's ability to get those services, and that we are twisting the juvenile detention scheme on its head, sort of manufacturing this tampering charge as a basis for probable cause to hold a child for whom there was no probable cause, and then trying to show in the absence of any indication that he won't appear at the next court hearing after having done so consistently, that sort of, oh, but competency restoration will be easier or evaluations will be easier if he is detained. That is, first of all, not the question. And I think that the record shows that to the extent that we have concerns, the juvenile delinquency system is the wrong system to address those. JR is a child with special needs. He has an IEP. He has attorneys who are working on getting him an inclusive placement in school so that he can get these services and so that he is with people who recognize that behaviors like tearing up pieces of paper towel and throwing them or trying to hug people are manifestations of his disability that should not be viewed through a criminal lens and used to hold him in detention. And that detention is inhibiting the process of getting JR these services, of getting him in school that can help address these needs. It is inhibiting that process. It's preventing him from getting the appropriate public education that he requires under his IEP. And so to say that he needs to be detained to secure presence at the next court hearing, again, in a court case where he's incompetent to stand trial on misdemeanor charges of failing to charge with
He's
BPS
also
device,
facing the UUV charge.
but there's no probable cause on those charges. And so there's no question that he's not being detained on
No.
those charges. He's being detained only on the tampering charges. And to think that we need to secure his presence at the next court hearing, sort of with the near future prospect of a trial completely taken off the table, when the record shows that to the extent there are these concerns, I think the government is trying to argue for sort of a more deferential standard of review to account for concerns about JR's needs, getting him evaluations. And what is manifestly clear from the record is to the extent we have those concerns, the council have made clear those don't go under 2310. And here detention is not only harming JR in the way the council has said detention always harms children, it is harming him by depriving him of the appropriate public education that the district is obligated to provide him.
This is a practical matter, and how this bears on what we're supposed to be analyzing, I don't know, but is the notion now that he would be in YSC until his competency is restored? I mean, presuming that if we were to affirm, would he be detained until his competency is restored?
I think that if he is found detainable, there is no endpoint in sight. And I think that if things that are clearly manifestations of JR's disability continue to be viewed through this criminal lens as bases for detention, we're not looking at any endpoint for detention, unlike sort of in the ordinary case, even of children facing much, much more serious charges where detention would be time limited. There's sort of a long time that he could potentially be detained. And that's what we're looking at. And sort of these competency restoration services are provided to help JR understand the trial. Those go to like, this is a prosecutor, this is a judge, those sorts of things. They're not services that are sort of addressing the underlying needs. And the record makes clear that for those services to be provided for JR, he can't be at YSC where which is overcrowded and many kids aren't receiving education at all. He should be in the community with people who understand how to address his disabilities. And I think that since sort of these issues about abscondence happened, the people in his life have gained new information. He received a diagnosis on October 1st, after these issues with missing CSS visits, after these issues with abscondence has happened. And that equips the people in his life to better respond to the challenges that JR has faced with doing what he is supposed to do all the time, challenges that have never affected his appearance in court.
Can I ask you some of these factors that you mentioned, like the competence, the ease of conducting the competency evaluations, and so forth. And the throwing of the paper towel that you're suggesting are not appropriate considerations for deciding whether he's going to show up to court. Are they appropriate to considering placement of one place or another? And can you tell from the record whether the judge is actually if so, I'm not sure what the answer to that is, but if so, can you tell whether the judge is relying on that? I mean, there does seem to be a lot of that kind of thrown out, and it seems to be in play, and it does seem like the judge is considering that, but what is your view of that? Does that
So
make sense?
my view is that the October 24th order, which the government recognizes is a detention order, detaining JR at YSC is reviewed the same way detention orders are always reviewed, which is de novo for sufficiency of the evidence for satisfaction of one of the two limited detention criteria by clear and convincing evidence. And so I think the government, though recognizing that this is a detention order, to the extent it tries to suggest there's something different that is a placement decision, it has no support whatsoever in its briefing for the idea that that's an inquiry that operates differently, that you wouldn't have to still show by clear and convincing evidence that the detention criteria are satisfied. But I actually think in this case, there's no sort of parsing the placement versus detention question, just really has no place. October 24th is the first time that an associate judge ruled on detention. And so the question before this court is, were the facts on October 24th sufficient to meet the government's burden to show by clear and convincing evidence that JR was detainable, and he was not?
Before you sit down, could I just ask you, I don't think this clear and convincing evidence standard that you're positing, to the extent it applies in adult prosecutions, it comes from a statute, the statutory language. There's no comparable statutory language in the juvenile context, and it has led me to question whether there's any sort of clear and convincing evidence requirement in the juvenile context as a condition of detention. As I said earlier, I'm inclined to think there is clear and convincing evidence here, but put that aside, maybe there isn't. But where does that standard, in your view, come from?
So in the adult context, cases like Kleinbart make clear that though now it is, I'll grant, a part of the juvenile, the adult statutory scheme, that wasn't always true. And so in cases like Kleinbart, the court recognized that the clear and convincing evidence standard has a constitutional valence when liberty is on the line.
I don't know what constitutional valence means. I mean, I thought the Constitution simply requires probable cause for detention.
This court in Kleinbart recognized that the clear and convincing evidence standard, which was considered in Salerno, has constitutional import. And so I think there's both a probable cause, sort of Fourth Amendment requirement basis for detention. That's Gerstein. There's also a due process basis when we're talking about a liberty restriction. And so that is why in the adult context in Kleinbart, the court is directly talking about clear and convincing evidence as something that comes from the concern when the legislature has made limiting criteria on detention in the face of the significant liberty interests implicated.
A Gerstein proffer, Gerstein proffer is simply a proffer of probable cause, for example.
Right, and I'm saying that is,
you're allowed to detain.
You are only allowed to detain if detention is warranted under the statutory criteria for detention.
Right. I mean, as I say, the statute, I understand the statute, the adult statute has a clear and convincing evidence component, but I don't see that in the juvenile statute.
Well, what Kleinbart says about reading the statutory criteria for detention is that when when there is a liberty interest in stake as a sort of as a due process matter, that the close scrutiny matters. And I think that's even more the case in juvenile court. What the council has made clear is that we are even more concerned about detention of children.
What does
It
there
is-
have to be clear and convincing evidence of, in your view? Namely, is it clear and convincing evidence that, in this case, detention is necessary to ensure that the child will appear in court?
that detention is required to secure the child's presence at the next court hearing. Yes.
I would assume your answer to this will be yes, but your position, I presume, is that even under a preponderance standard, it was not satisfied here?
Yeah, my position is that this court doesn't have to decide the standard of proof, and that this court can look, as KG did, to the legislative backdrop where the council has said we are seriously concerned about detaining children. It is to be used as a last resort. And so reading 2310 A2 through that lens, as the court in KG did with 2310 A1, leads to the conclusion that against the backdrop of how harmful detention is to any child, and then against the backdrop of how particularly harmful it is for this child, is detention nevertheless required to secure the child's presence at the next court hearing? And so the court, in my view, does not have to resolve questions about the standard of proof, because when 2310 is read in light of the plain text and the clear legislative purpose, it's clear that detention of JR was not required. If there are no further questions, we ask the court to reverse.
Thank you. And we'll give you some time on rebuttal.
Good morning. May it please the court. Jeremy Girton for the District of Columbia. The court should affirm the detention order here, which was based on a valid finding of probable cause and a reasonable conclusion that detention was necessary to secure JRR's presence at the next court hearing. I want to just say a couple of words on the standard review issue that Ms. McDonald was just discussing. I think I agree with her last statement that the court really doesn't need to decide anything about the standard of review here. I think you can harmonize KG with the earlier cases that we cite, and recognizing that the sufficiency test is very deferential to the fact finder, but there is a kind of evidentiary minimum, as we talked about in the last argument, that does need to be met. Even KG does not adopt this clear and convincing standard that they're proposing, and I don't think this court has ever adopted it in a juvenile context. It does come from the adult statute 1322B, which in turn is modeled on the federal statute 3142F, but it has never been put into the juvenile statute. I don't think this court has ever really discussed the standard. I agree that we would clear the clear and convincing standard if that was what was imposed, but I don't think the court really needs to comment on it at this point.
Does the government have an opinion on it, though? I mean,
we haven't taken an opinion on it. I don't think it's necessarily appropriate to import a statutory term from a different statute that is absent from the juvenile statute and
so
bring
that
it
is,
in.
I guess, what happened in the adult context first before it was added to the statute, right?
Well, my recollection of the cases, and I admit it's been a little bit since I looked at this, but my understanding was that Salerno was a statutory interpretation case about the federal statute, and then we sort of imported it through a court decision, but not because of constitutional reasons. I think just because we were operating in parallel to the federal scheme. So I don't think the court has ever said that it's a constitutional requirement in the adult context. And now it is written into the adult statute. So unless the court has any other questions on standard review, I wanted to just say a few things about the probable cause argument. I think all the court really needs to say here is that the GPS tampering statute says that if you are required to wear a GPS monitor while on predisposition release, and you tamper with that device or fail to charge it, you can establish probable cause for violation of that statute. And I agree with Ms. McDonald that the word required does mean that it has to be required by someone with authority, But I don't think that that means you get to collaterally attack the substance of the order that required you to wear the GPS.
Is this just a matter of not taking that administrative step of, having these conditions removed?
I think that's one part of it, but I think another part of it is just that because they didn't take that step, the condition wasn't removed and the order remained in place. And so it still was a valid order.
Do you agree that they should have been removed or could
No,
have?
no, I don't think they should have been, but I don't think the court needs to actually decide that question, but I'm happy to discuss that. But certainly by not removing the condition, the court order remained in place. I don't think there's any question about that. And they had the opportunity to appeal that if they had wanted to, but they didn't, or object, or say, Your Honor, now that you found no probable cause, we want the monitor removed, but they didn't do any of those things.
Why is it not a nullity?
It's not a nullity because the court order remained in place and I mean, there was even a discussion on, with JRR and the court asked, do you understand this to be an order? And he said, yes, I understand it was an order, not a request. So that's sort of, everyone was under the understanding that this was a valid order that remained in place. And I think the implication of their argument would really allow improper collateral attacks in a number of circumstances. I mean, if you analogize to someone who's maybe been charged with being a felon in possession of a firearm, they don't get the, when they're charged with felon in possession, they don't get the opportunity to say, well, my original conviction, my original felony was invalid for some reason because the trial court, allowed hearsay testimony at my trial and that was improper. You don't get to kind of collaterally attack that underlying felony when you're charged with a new offense based on it. And I think
It's
that
very different though. What about in Re QB?
so I think QB has a number of distinctions from this case. First of all, it's under the contempt statute. And my understanding of what QB was saying was that there was no disobedience of the order because the order itself was just an agreement that provided the consequence of not obeying the curfew was going to be detention. And there had already been a probable cause finding and detention had already been ordered. And so the court was kind of entering an agreement with QB to, I'll release you, but if you don't follow the curfew, I'm going to step you right back up to detention. And that's very different than what we have here, where the GPS monitor was imposed prior to a probable cause hearing. So we all agree that at that time, detention wasn't on the table. So the court couldn't have been entering any kind of agreement with JRR to, say.
It really the same? It's like detention, you wouldn't be agreeing to these conditions if detention weren't on the table.
Well, I don't think he had to agree to them. I think the court just ordered them. If you look at the order, it doesn't have, a signature block for JRR to agree that in exchange for anything, I'm going to comply. It's just a court ordering a juvenile to comply with a condition. It's not optional. It's not an agreement.
But what happens if they are not, it's on pain of detention, right?
Well, potentially, if probable cause is later found, but I also think it's on pain of violating a separate criminal law that prohibits you from tampering with the GPS monitor. And that statute, all it says is that you're required to wear it. And I think to Judge Glickman's point, their interpretation would not only make the GPS monitor order a nullity itself when it was entered, because there would be no way to enforce it. And it would also make a lot of the section 1211 a surplusage because under their view, you could never order a GPS monitor on predisposition release for a juvenile because they don't have a probable cause finding. So the statute which says it's unlawful for a person who is required to wear a device while on predisposition release to do any of the following things. I mean, that whole reference to predisposition release would be surplusage.
So you think the extent to which a juvenile is required to wear the GPS device is identical at the outset to, identical whether they just came in on this case or after no probable cause has been found? It's the identical stature.
Yes, because they're in the same place in both instances, right? We don't have a probable cause finding, so they can't be detained yet. But the court can impose conditions, it can impose requirements on their release. And I think that's very clear from the text of 2312.
How can you have a condition on release if you can't be detained?
Well, maybe that's condition is the wrong word then. Maybe I think of it just as
That's
a
what you
requirement.
mean, right?
Yeah. It's just a requirement that you obey this because I'm releasing you. You have to follow it. You've been charged with a crime. You know, some of the conditions or requirements could trigger a contempt charge or a GPS tampering charge. Or there's always the possibility that
That's not precluded by NREG QB?
I don't think so, because I think if you read INREG QB in conjunction with Jones, which it primarily relies on, it is talking about whether there is a violation of a court order at all. And Jones, I think, is a clearer example where the court order just said you can't use drugs if you want to continue having visitations with your children. And it was clear that the consequence of using drugs was not anything other than that visitation rights would be removed. So the person didn't violate the order when he used illegal substances. There wasn't ability to hold him in contempt because there wasn't any kind of violation of the order. And I think that's what QB is talking about. Here, there isn't kind of that pairing of the condition or the requirement with the consequence. It just says you're required to do this, which I think is, even under the language of QB, a freestanding obligation to obey the court order.
I don't know if you finished providing your answer as to how a juvenile is identically situated prior to any probable cause hearing and after a finding of no probable cause.
Yeah, so I think there's a number of reasons why they're in the same position. One is the petition remains. Everyone agrees you can go to trial on the petition. Everyone, well, I guess not everyone agrees, but we think it's clear that you could have a reopening or a new probable cause hearing. Nothing in the statute prohibits that. And I think the analogy to the adult context, I think that Ms. McDonald was making was a little bit inapt. I think the analogy of the probable cause hearing, the analogous event in an adult context is the probable cause hearing for a felony charge under 5.1, which at the conclusion of that, if you find no probable cause, the charge is dismissed, but it is explicitly under 5.1E without prejudice. So the government could rebring that same charge against the defendant again. And so I don't think there's really any, and here there's not even a dismissal. So it's just, it remains. So the person stands in the same place. They're still charged with the crime. They could still have a trial on it, and they could be found responsible and, you know, have whatever penalties or you know, rehabilitation that the court orders at the end. So I don't see how that's any different than where they were before the probable cause hearing, when the court obviously doesn't have a probable cause finding that it can make. It can't order detention yet, but it can still, under 2312, impose conditions. And those conditions explicitly say you can condition them on returning to the custody of their parent, restricting their movement, or any other condition necessary to secure their presence.
You agree that, at least for some of those conditions, there is a constitutional problem of imposing them in the absence of probable cause?
I don't think so in the juvenile context, and I would point the court to Shaw v. Martin, which is post-Gerstein Supreme Court case about juveniles. And that case endorsed detention of a juvenile for a brief period of, I think it was up to 6 days, prior to a probable cause hearing, and said that that was constitutionally appropriate. And so it has to be the case that if you can detain them without probable cause, which under the statute you couldn't do, but I think constitutionally Shaw says you can.
Just asking about the Constitution.
Yeah, so constitutionally, if that's permissible, I think lesser restrictions like a GPS device would certainly be constitutional as well. But I think all of that.
So you think Gerstein might apply in the adult context, but not quite the same way in the juvenile context?
I think that's right. I mean, Shaw discusses Gerstein at length and talks about how when you have juveniles, this circumstance is totally different. And the whole point of the juvenile system is totally different than the adult system. I mean, it's a rehabilitation system. It's not a criminal proceeding. It's not about punishment. It is all about rehabilitation. And the court and the government, the state stands in the place of a parent.
At the hearing below, forget about which hearing I'm talking about, at the hearing below, was J.R.R.'s mother present?
Yes, I think, I'm not sure if she's been present at all the hearings, but she's certainly been present at several.
Did she ever object and say, or did she take any position at all on whether it was appropriate or permissible for her son to be required to wear a GPS monitor?
I'm not aware of any objection about that. I'm not sure she was asked, but I'm not sure she said anything about it. But, you know, the language that the court used in Shaw says juveniles, unlike adults, are always in a form of custody because they're either in the custody of their parent or they've been moved to the custody of the state.
Have we ever, yeah, I mean, you see where my thoughts were going. I don't know if they can go there very far, but has this court had occasion to ever discuss the implications of Shaw?
I'm not aware of any that talk about it in this context. But I think the court has said several times that juvenile proceedings are very different than adult proceedings. I think everyone recognizes that. I think you also have to recognize that the government simply, or the court, has greater ability to control the custody of the juvenile than an
Could the
adult.
court, in the circumstances of this case, in the absence of probable cause, could the court have ordered home detention?
Yes, I mean, essentially that's what it did when it imposed a 24-hour curfew. It said you need to return to the custody of your mother, and unless you're going to school, you need to remain in your home. And so that was another condition imposed pre-probable cause hearing. And I think that is explicitly one of the conditions that 2312 says you can order. It says you can order placement and restrictions on the child's travel activities or place of abode during the period of release.
I mean, many of these conditions impose not insubstantial restrictions on freedom of liberty and intrusions into the privacy of the, in this case, juvenile. And it is interesting to consider that presumably without probable cause, well, without probable cause, could those sorts of restrictions be imposed on adults who were brought into the criminal system?
Many of them can. For a misdemeanor, you don't have a right to a probable cause hearing. You just have the Gerstein affidavit. And I think the analogous
Well,
thing is the
but the
Gerstein
judge is
affidavit.
determining based on the affidavit that
Right.
it could be challenged.
Yeah, but it's not a full-fledged hearing the way you have for a felony, yeah. And I agree, these are sort of difficult questions. I think it would be more appropriate to address them in a case where we're not on such
I
an
wonder
emergency
whether the
posture.
forfeiture of all these claims, I don't know if you want to speak to that.
We do think they were forfeited at least twice. The first time when the conditions were imposed and there was no objection or appeal, when the probable cause hearing happened and there was no objection or appeal, and then I think
Why is it a forfeiture the first time? When, you know, there's the no probable cause finding hasn't happened yet.
well, I understood Ms. McDonald's argument, and maybe I'm misunderstanding it, to be that without a probable cause finding, you can't order GPS monitoring at all, even before the hearing.
She was saying we don't have to get to that, but
Well, I think it would be the natural, if it's true that it's unconstitutional without a probable cause finding, then I don't see why it would be different pre-hearing than post-hearing. I mean, in neither case has the court made a probable cause finding. So I think the natural implication of the argument would be it would be unconstitutional even before the hearing. And so that should have been objected to when it was first imposed. As should have the curfew and all the other conditions and requirements that were imposed. So those are the first two instances where we think it was forfeited, and then we think it was forfeited again when they didn't, when the magistrate judge was deciding whether there was probable cause on the GPS tampering charge to not say anything about the validity of the underlying requirement.
It may be that the forfeiture relates to whether a constitutional claim is now preserved. But what do you say to Ms. McDonald's point that forfeiture does not really pertain directly to, doesn't make something that wasn't required under the tampering statute now required?
I think that argument might have some more force if the order had been lifted before he was charged with GPS tampering. So I think there's two separate problems there. One is that the order remained on the books, and relatedly, they never objected or tried to appeal that order to get it off of the books. So I think those are kind of two separate problems. But even if they had objected and had appealed, and the appeal was pending when he was charged with GPS tampering, I still think he was required to obey the order until it was lifted, just as you would for any
Right,
other
but he
order.
wasn't required because it's not that he forfeited an argument that he wasn't required to wear it. It's, you're just saying that he was required to wear it because he was still required to wear it.
That's one reason. And then I think separately, he forfeited the chance to even challenge the original requirement, and he forfeited the argument once he got in front of the magistrate judge on the tampering charge. He forfeited the argument that the underlying requirement was somehow invalid. So even if you can collaterally attack it at that point, he didn't. So that's a separate forfeiture, I think.
I understood Ms. McDonald to be arguing that a juvenile cannot be held in contempt. I may be stating that a little too broadly, but that's the gist of what I understood. Do you take a position on that?
I don't agree. I think QB is pretty narrow and is talking about a circumstance when a condition of predisposition release is tied to an agreement not to place the juvenile in detention. And the juvenile violates that condition, as QB did, which was a curfew condition. The only remedy is to just reimpose the detention that had already been ordered. And so the person hasn't violated a freestanding obligation of the court when they breached the curfew. But that's different than a freestanding order to wear a GPS monitor that we have here. And I think he could be charged with contempt for violating that because it wasn't part of this kind of conditional agreement. I mean, it couldn't have been part of a conditional agreement at that point. Because there was nothing the court was giving up as a bartering chip in exchange.
Sort of her point, I think. Guess you're both using it for your own argument.
Well, if their analogy to contracts, I guess I would say there's no consideration, so it couldn't have been an agreement. It was just a freestanding order of the court. And so it would be, punishable through contempt as a normal court order would be. I think that's what makes it different. I think, they've raised a question about whether the court validly could issue such an order, whether it had the power to do that. I think there's a lot of problems with that argument, obviously, but I don't think that makes it an agreement, automatically. I think it's just a freestanding order, and they're making arguments about why it's valid or not. I wanted to address, unless the court had any other questions, Judge Shanker, your question about the time limit. I don't think that there is a time limit, but detention can always be reconsidered when someone's been held not competent to stand trial. And so he could be stepped down to shelter house or released if the court concludes in their interim that that's appropriate. So I don't think it's necessarily the case that he's going to be at YSC forever.
How would that be? How would that happen? And would JR have to file a motion for reconsideration of the detention order, or?
Well, I think as his counsel has done at every status hearing, they have asked for him to be released, and I expect that they could do that again, and the court would say, I'm not reconsidering, or I am reconsidering detention, or I'm reconsidering placement. I mean, I have no doubt that they will continue asking for that at every opportunity, and so the court has that chance to talk about what the current situation is. So unless the court has any other questions, we would ask the court to affirm.
Can I ask you, what about Ms. McDonald's point about how this looks a lot like criminalizing JR's diagnosis? I mean, there's so many aspects of this. The failure to get to, I mean, a lot of the things that the evidence that's being used to support the detention decision look like things caused by his autism or caused by his, not even anything he's done, but his mother's failure to get him to his meetings. What is your response to that?
My response is I don't think predisposition detention is ever really understood to be a punishment. I mean, the statute doesn't permit that purpose, and I don't think that anything that either the magistrate judge or the associate judge said was that they were imposing detention because they wanted to punish or they wanted him to understand the lessons of not complying. It was, I'm not confident that he's going to show up to the next court hearing, so I am going to order detention to secure that. It's not about you did something wrong and therefore you need to be
So could,
punished.
if it were entirely on his mother, we could detain him for that reason?
I guess I would have to think about that. I mean, there's other provisions that allow the court to take custody of a child if a parent is failing their obligations. I'm not really sure that failing to get them to a court appearance would meet that standard. But there's certainly other options there. And I don't think that these are all on his mother. I mean, the abscondances, the not attending school, I don't think any of those are really even argued to be attributed to his parent.
Although a lot of them do seem attributable to his autism.
Potentially, I mean, that's their representation. They haven't offered any expert testimony on that. And I don't think that,
I mean, and his, you know, that he's at a first or second grade level.
right. I think the court can certainly consider those
Mhm.
things, but again, whether someone's going to appear at court or not is not tied to
Yeah, it just seems so
intentionality.
disproportionate where he's made every single court hearing on this one side. And there are some other things that make the court a little nervous that he might not, and they're
Mhm.
not really all, you know, some of them are because his mom can't get him there. And then on the other side, we have the council saying, we think that detention is bad for kids, you know, the amendment, talking about, you know, the brain development and how, kids are, you know, more likely to be recidivist, more likely to be harmed in detention. We've got a presumption, that, you know, it should be the last resort. And then these odd facts of, you know, this all happened when he was charged with the UUV, that now there was kind of sketchy, not even sure there's evidence that he was one of the 4 kids. That was the problem with probable cause at the hearing. At best, he's a passenger, so he's not even the driver. It's found, you know, no probable causes found on that. Then he's later arrested on a quashed custody order for failing to charge a GPS device, such a, you know, minor misdemeanor. It just seems so disproportionate.
Well, I don't want to minimize the preference for non-detention. I agree wholeheartedly that that's a big part of this statute. But I do think it's the only thing on their side of the ledger for why he's likely to appear at court appearances is that he appeared 4 times. And I think if you actually look at what happened in those instances, 3 of those 4 instances came on the heels of him being picked up or located by police or through his GPS monitor. So the first voluntary appearance on August 25th, he was responding to a custody order that had been issued by the court 5 days earlier. So there was an order out for his arrest or pickup by police at the time. So I don't really consider that a voluntary
So
appearance.
was he brought to court by police?
He voluntarily came, but in response to the court having to order his return to custody because he had run away from his mother's care. The second voluntary appearance was 2 days later, only because the day before he had been found by his grandmother and police using the GPS monitor that had been just imposed. So that one, the only reason he was able to get there into custody of his parent and to court was because of the GPS monitor.
And the only reason, you don't really know what would have happened without that. Maybe he would have come home, you know, like.
Potentially, but the day before the hearing, he was found in an abandoned building. The only way that his family and the police found him was through the GPS monitor. So he obviously was not responding to them or they weren't able to find him. The next one is September 2nd, which I agree, he did voluntarily appear, but again, that's after the GPS monitor has been imposed. And then the final one on October 2nd, that he had been picked up by police and had been missing for several days just before that hearing. So again,
What do you think about Ms. McDonald's point about the families kind of, they just have this new diagnosis and they're kind of getting the hang of it now. Everyone's on notice that this is an issue, get to court, get to court. They have always gotten to court, but now they definitely need to get to court. Does that move you at all?
It doesn't, because I think, to Judge Shanker's point about the court services visits, there were 5 of those. They are just as required as a condition or a requirement of his release, as is the curfew and attending school and all of the other things that he violated. They obviously weren't successful in getting him to those important meetings with his probation officer. So
The lawyers go to court, right? And going to court is the thing that's in the statute.
Fair enough. I agree that with Judge Glickman's or the kind of premise of Judge Glickman's question earlier, that there's really not anything other than their say-so that they would help him get to court. And that they're appearing in court at the same time. It's not like they're picking him up and transporting him there themselves.
Their say-so, I imagine, would carry some weight.
Sure, but I don't know how much weight you can give it when they haven't been able to get him to other required events, and we have this history of him running away and not charging his GPS monitor. I don't know how his counsel would be able to find him such as to secure him for a court appearance if he's run off to some abandoned building and there's no GPS tracker and his family can't find him. I think this is a very strong case for some form of detention being appropriate, given this history. We obviously we didn't seek it initially. We waited and the court tried to do some lesser measures.
Why is the government defending the YSC choice now instead of saying, yeah, we agree with that, as the position that you took in the trial court, that shelter care would be okay?
So a couple points on that. We didn't take a position either way on which form of detention at the trial court, and we don't take a position kind of de novo now. But I do think that the trial court has broad discretion about placement, and there were factors that the trial court cited as the reason for the change in placement. And I think those are kind of within the trial court's discretion. So I think it is affirmable. I do think there's an issue where that is a separate placement order that was entered after the detention order, and they did not appeal that separate order. I think they probably could have, under the kind of ongoing case SM that I'm sure the court is familiar with, about whether that's an appealable order, but they didn't appeal it. So I do think there's kind of a jurisdictional problem about the placement order, but even if the court thinks it's kind of wrapped up in the detention order, I think it's within the court's pretty broad discretion.
Mr. Girton, you pointed to, I think, at least 2 of the successful appearances at court that were, in your view, caused by the fact that he was wearing a GPS monitor. So seems to follow, this is kind of meta at this point, but that he's now, the petition is on a tampering charge. So if he were to be, he could be released with the condition that he wear GPS monitoring, not in connection with the auto theft charge, but with the tampering charge. And why wouldn't that still have the same force with respect to getting him to court on the tampering charge?
Well, I think it wouldn't have the same force because he didn't charge the GPS. We know that he has a history of not charging it. And so it's not effective as a way of getting him to court if he doesn't comply with the requirement that he charge it. And so he was given that opportunity to be released with a GPS monitor as a lesser potential form of restraint than a detention, and it wasn't successful. So that's why we've moved into detention at this point. So I think you can look at this history as the court really taking incremental steps where it was being restrained in, the initial conditions it imposed, then it imposed a larger curfew and a GPS monitor, and then ultimately detention because none of those steps were being effective at ensuring that he was going to appear. So unless the court has any further questions, we would ask the court to affirm.
Thank you very much. Ms. McDonald, we'll give you 3 minutes for rebuttal.
Thank you. I have a couple quick points. I want to start with the 2310 matter and just emphasize that because we are in the world of competency, as Mr. Girton acknowledges, we're looking at a prospect of up to a year. And if the court upholds the detention order now, all of the things that the government is relying on, the missed court visits, the abscondances, those facts will never change and will continually be the basis for saying, well, when he was released, these things happened. And so I think we're looking at sort of an indefinite period of detention of this child who needs services, who the district has an obligation to provide services that meet his disabilities that he's not getting in detention. I also want to talk about the abscondances and what the record shows about them, which is very little. And I think these abscondances, by and large, are abscondances in the sense that they were curfew violations, but the government's suggestion that JR, who's 13, was totally off the map and no one knew where he was is actually unsupported by the record. So the government talks about this period when he was away, which has been deemed an abscondance in August for a week. And actually at the August 27th hearing, the judge asks his mother, well, did you know where he was during that time? And she says, yes, I did. And so it is an abscondance in the sense that he had a curfew to comply with that he wasn't complying with, but there's no indication that people didn't know how to locate him. There's one time in the record where there's a suggestion that people didn't know how to locate him. That's on September 29th, where the probation officer describes the mother as, quote, looking everywhere for him. That doesn't come from the mother. We don't know that no one knew where JR was. And at that point, even without a GPS monitor, he returns home one day later and then he shows up in court. So I think these abscondances have to be viewed as 106 requires in context as not a situation where this is someone who's leaving the district, who's not going able to be found. His mother knows where he is. He's getting, there's no record evidence. And I think the record suggests actually that people know where he is. He's getting to court. So I think that when those abscondances are viewed in context and I think both the abscondances and the missed CSS visits are really the only things the government is pointing to overcome the strong record evidence of JR appearing in court. And as to both of those, both the abscondances, the neuropsychologist has said these are related to the diagnosis. These are elopement is a symptom of autism, which he has just been diagnosed with, was diagnosed with after all of these abscondances happened. And when we look at no one didn't know where he was, those nor the CSS visits, which are related to issues with his family getting there, can overcome that strong evidence.
I understand your,
Please,
sorry,
go
thank
ahead.
you. I understand your sort of, I mean, this might not be the right word for it, but policy concerns about sort of punishing these diagnosed conditions. But what's to stop a court from saying, it doesn't matter what the reason is to me if you are unable, and I know you're disputing the notion that he might not appear for the next court appearance, but if the determination is you are unlikely to appear at the next court appearance, whether it's because of mental deficits that prevent you from getting here, or because it's unfortunate, but your mother works and can't get you here, or it's because you don't want to be here and you're running away. Does it matter what the reason is?
I think it matters what the reason is to the extent that, again, 23A2 is only concerned with appearance in court. So if the reason is related to things that are sort of personal to JR, being where he's supposed to be on his own, like showing up back home from school, or things that are all sort of on him and are related to his diagnosis, that's different than when we're coming into court with a support system of his parents who are able to be there with the defense team. So I think it matters in that sense. It also matters in light of, again, the backdrop where detention is, the presumption is against detention. And so the detention analysis, sort of as KG recognizes, has to account for the harms of detention. And despite those harms, is it required? And the harms of detention here, the record shows, are that JR is actually being deprived of the services that could help with these issues that we have just learned more about. I want to briefly touch on the probable cause issue, just back to the analog to the probable cause hearing. And the government says that it is the preliminary hearing, but the preliminary hearing is about probable cause on the charging document. And what MAPV Ryan says is in the juvenile context, you don't need that. And so the probable cause hearing that we have here is a more robust version of what adults get at the Gerstein stage. In the adult court, it's an affidavit. In juvenile court, you get a full hearing. And Schall is, as Mr. Girton acknowledges, sort of recognizes, it's not saying Gerstein does not apply in the juvenile context. And I would urge the court to look at what Lefebvre says. We've cited Lefebvre in our opposition about Gerstein in the juvenile context, and the recognition that Schall is contemplating a juvenile scheme like this one, where juveniles actually have sort of more procedural rights at the Gerstein stage, a fulsome probable cause hearing because of these due process concerns about liberty. And so, as Mr. Girton said, it's a timing point. It's really more of a Riverside point than a Gerstein point about, this can happen on a longer timeline because of these additional protections that are happening. And so Lefebvre says that reason, this sort of more robust concern that we have about detaining children, that shouldn't be a reason to say that sort of Gerstein doesn't apply or Riverside doesn't apply in juvenile court. It's a reason to say we are especially concerned about it when it comes to kids. And Lefebvre is expressly discussing Schall, and he is still saying, full stop, Gerstein applies in juvenile court. No court has held otherwise. And the government's reliance on Schall really doesn't get us there. And so I think what the government is asking this court to do requires the court to determine that what happened here in the face of Gerstein was constitutional, that it was constitutionally permissible for JR to be on restrictive GPS monitoring after a judicial finding of no probable cause. And I think for the court to dive into that constitutional question, we are not asking the court to reach that. If the court looks under QB, which I want to emphasize that JR signed the exact same agreement that QB did, word for word. JR signed the same conditional release order that is quoted in QB. The above checked conditions of release have been explained to me, and I agree to comply with them to the best of my ability. I understand that failure to comply with any of these conditions may result in my placement in a secured or unsecured facility until final disposition of my case. And while it's true that QB had already been detained, there wasn't the probable cause problem in QB. It wasn't the case that QB could automatically be detained if he violated the release conditions, because it's always true in juvenile court, unlike in adult court, violation of release conditions isn't an independent statutory basis for detention. So they were always still going to have to show, are you detainable under 2310? So it's not as if QB is in a different posture in that he was full stop detainable. He, like JR, was potentially detainable. And I think the government also points to, well, here the GPS condition is technically on a different form, it's on a different order, but even the government has recognized in their briefing that the GPS monitor was a condition of release, and QB's holding covers conditions of release in the juvenile context. I would also point to the GPS order itself and what it says, which is very little. It doesn't say you're required to do it. It says, 2, electronic monitoring to be installed before leaving the courthouse today. GPS monitor to remain charged. Failure to do so will result in a custody order being issued. There's no basis, unlike in adult court again, there's no basis statutorily for this to be the subject of contempt. And even what it's saying here is if you don't do it, there's going to be a custody order issued. Not you're going to be subject to contempt. So the idea, and this order clearly has to be understood to relate back to that earlier conditional release order as a new condition of JR's release. And so that is why the QB is precisely the same. And so that sort of agreement, once the prospect of detention, which is as true here as it was in QB, is taken off the table, there was no requirement to speak of. And if the court understands the tampering statute 1211 in that light, I just want to emphasize how few implications this has for other cases. It would reach the exceedingly, exceedingly narrow class of cases where a child is put on GPS monitoring, there is a finding of no probable cause, and then the child remains on that GPS monitoring and is subject to a tampering charge. That is and again, as we've said, it's exceedingly rare that a finding of no probable cause happens in juvenile court. So this isn't going to wreak havoc in the tampering statute. It is a very, very limited holding. And it would provide that because of QB, because the nature of the conditional order, there was no requirement under the tampering statute which is entirely consistent with the purpose of the tampering statute, which is to get at interference with monitoring when the government has the lawful authority to monitor someone. So for these reasons, we would ask the court to reverse.
Thank you very much. Thank you both for your arguments today and all of your briefing. We'll consider this quickly and issue an order in due course.
All right.